Last case we have this morning is People versus Cameron. The appellant will have 15 minutes. The appellee will split their time, 10 minutes and 5 minutes. And we will hear for 5 minutes from the Amicus curiae representing the Michigan District Judges Association. Thank you, Counsel.
Good morning. May it please the Court. Marilena David Martin from the State Appellate Defender Office on behalf of Mr. Cameron and Jacqueline Ouvry at co-counsel table. I will reserve 2 minutes for rebuttal and will keep my own time. A tax by any other name would still be a tax when its purpose is to fund the operation of government for the benefit of all members of the public. All criminal cases begin the same way. People of the state of Michigan versus someone. There is no doubt that the public and general members of the public are the primary beneficiaries of the operation of the court system. It's true that Mr. Cameron also benefits from the court system. But as this court has laid out in Bolt, the fact that a criminal defendant benefits from the court system has no bearing on whether or not that should be the sole analysis of who the primary beneficiary is, which in this case is the general public. The Bolt test is applicable here and easily applied with no problem because the three-part test is consistent with the way this court has defined various exactions over time. The legislature and the prosecutor can call the exaction in the court cost statute whatever it likes, a cost, a fee, an assessment, an administrative defrayal. Whatever it's called doesn't really matter because what matters is how this cost is or this exaction is functioning. And here, there's no doubt it is functioning to raise revenue for the support of the operation of the court system. I invite questions at any time. The Bolt test, which, as I said, is consistent with what this court has said the definition of a tax is important here. The revenue-raising measure of the court cost statute could not be more clear. $40 million each year is raised by the court cost statute, as we've seen from the report submitted by SCAO. The intent and the spirit of this legislation was to overrule this court's decision in Cunningham, was to put a Band-Aid on the problem that the trial courts are not properly funded. There's, again, nothing more clear than that this is a revenue-raising statute than by looking at why the statute was enacted in the first place. It certainly
Counsel, of course it raises revenue. That's not really the decisive issue. I mean, I thought the more relevant issue under Bolt was the extent to which that revenue was proportionate to the costs that were incurred by the process, whatever that process might have been.
Correct. And the proportionality factor is also extremely important here. And the test that this court laid out in Bolt was that the charge imposed must correspond to the benefits conferred and that the benefits conferred on the payer have to be greater than the benefits conferred on the general public. As this court knows, in the calculation of what the court cost is in this particular case, the court looked to the annual budget and the averages of the operation of the court system. It has no bearing on what Mr. Cameron's individual actual costs were in this case because, again, he could have been in the system, or any criminal defendant could be in the system for maybe 2 months, yet the average calculation and the way that the court costs are being assessed in cases across Michigan is to look at annual budgets and averages of annual budgets. They're also not limiting, for example, the severity of the offense or the complexity of the offense. And you can't. And that's one of the reasons why the court cost statute just doesn't work, because you can't you can't really say, if you file more motions, you're going to be charged more, because that would create all sorts of other constitutional problems here. You can't place those limitations on criminal defendants because of the chilling effect that it would have. The costs in this case and in cases all across the state of Michigan have no bearing on the actual cost of what it takes for that particular case to process through the system, and that's why it just simply is not proportionate to the benefit that's conferred on Mr. Cameron.
Isn't it more fair to say they have an imperfect bearing as opposed to no bearing?
They being who?
Isn't it more accurate to say that this average calculation that's been produced has an imperfect bearing upon the costs in this case as opposed to no bearing whatsoever?
Sure, I think that would be fair to say it's imperfect, and you're right that it does have some bearing, so I shouldn't say no bearing because the courthouse is operating, and of course that's part of the calculation there. But in Cunningham, for example, when that case was remanded to discover what was going into the factual determination of what the annual or what the court cost should be, we found out that the courthouse gym was calculated as part of the finances for the court cost in Allegan County. So again, the costs don't have a relationship to the actual cost of the case, and the proportionality factor certainly fails here under the Bolt test. It's also unclear what's subtracted out of the annual court cost. So say a court determines this is the annual cost that it takes to run the felony division or the felony operations of the court. Are they subtracting grants that the court might get? Or are they subtracting state appropriations that the court might get? All of that is unclear and not really required by the statute, which, again, raises the separation of powers constitutional problems that I will discuss. It also fails the voluntary prong here, and so the prosecutors make much of the fact that Mr. Cameron and all criminal defendants could just choose not to commit crimes and therefore not be part of this court cost statute. But the test is actually, as explained in Bolt, whether or not a payer is able to refuse or limit the use of the service or the benefit. Here, Mr. Cameron is not able to refuse or limit the service or the benefit. If he commits a crime or anybody commits a crime, they're going to be processed in the circuit court where the jurisdiction lies. This is something that came up in Bolt, in which Justice Markman, in your dissent in the Court of Appeals, you mentioned that the use of an indispensable service cannot be considered a matter of choice when there's a municipal monopoly. And the same sort of thing exists. And the prosecution makes comparisons to sales tax of cars, and that's not voluntary either. But what is voluntary there is you can go and shop around. You can get a less expensive car if you want to. That can't happen in this case, and there's no way that the court cost statute satisfies that voluntary analysis in Bolt.
Counsel, let's talk about what. Assume we agree with you that it's a tax. The legislature outsources the governmental function of collecting taxes to the executive all the time, right? Why can't the legislature outsource the governmental function of collecting taxes to the judiciary?
The legislature can do so if the legislature provides intelligible principles and sufficient standards necessary to make sure that the will of the legislature is being followed. And here, the statute does not provide any limitations. At first glance, it might look like the language that the relevant costs have to be, or the costs have to be reasonably related to the actual costs incurred by the trial court. But the legislature is talking out of both sides of the mouth here, because it also then goes on to say it's including but not limited to everything and anything under the sun. So it leaves to individual judges to determine, are we going to calculate this? Is this person a relevant court personnel? Is this a necessary expense? What if the court staff needs upgrades in technology or software, or the courthouse needs new carpet? Is that a necessary expense of what is to be the maintenance and operation of the court system? So by just simply saying reasonably related, but reasonably related can be literally anything that the court can think of to operate the court, does not satisfy the principles or the test laid out for whether or not intelligible principles are there so that the delegation of taxing is valid. And the delegation of the legislature's taxing power is especially protected. It's a super special power that does not have the same sort of delegation principles when you're looking at, for example, delegation of the legislature's rulemaking authority. Instead, the power to delegate taxes is specifically protected, and the standards that are in the statute are no standards at all when there are no limitations. The court is free to raise its entire budget, if it wants, off the backs of criminally convicted individuals, because the statute doesn't say what can't be included. It's very important. The statute doesn't say, don't include this, don't include that, or these things are not maybe necessary or relevant. The court and the individual judges are left to decide what that means. The distinct statement clause is also violated because the fee is disguised as a tax. I mean, it couldn't be more clear that the tax is deceitful or obscure when the tax, it's coming off as like the prosecutors and others are asserting that this is merely a user fee, and then it does look like the person is assessed only a court cost. But in fact, in Dawson, the Michigan Court of Appeals, when examining the distinct statement clause, found that an assessment didn't violate that, an assessment that was a tax didn't violate that because the amount was clearly stated. Well, we can't correct that with this court cost statute because a flat fee would not solve any of the problems. A flat fee still raises the due process concerns that the Michigan District Judges Association lays out, and really only further amplifies the proportionality problem because the flat fee won't be taking into account anything individually related to certain cases.
Isn't the premise of Article 9, Section 2, which has to do with the power of taxation, that once you have sufficiently clear criteria and standards by which some other institution gets to make taxing decisions, they're effectively not exercising the taxing power, but they're exercising either the executive power or, as in this case, the judicial power. It's an ancillary power to their underlying executive and judicial responsibilities. Isn't that the whole response to the concern expressed about Article 9, Section 2, that the courts would not be exercising anything other than a judicial power when they determine cost? They're exercising a judicial power at that point because there's presumably sufficiently clear standards by which the so-called delegation has occurred.
So that would presume there are sufficient standards for the delegation to have occurred, which are not present in this case. And the judicial power to determine what the particular cost is different than the judicial power that's given to courts here, because a true cost is what does it cost to process this case through the system? What's the actual cost of taking this case and processing it through here? And that's not what this court cost statute looks at.
Well, I'm not sure I completely follow your analysis there. You were suggesting a few minutes ago one of the problems with this procedure is that we have the individual judges rendering the determination as opposed to some presumably more central authority like our Supreme Court Administrator's Office. I mean, wouldn't you expect that if SCAO was to be making all these judgments, they would be much less precise, much less in accord with the actual cost standard than when you actually have the individual judges rendering this decision?
Well, my understanding is that SCAO would never make this individual decision without taking into account the particular characteristics of the trial court budget. So the memo that SCAO produced asks the courts and asks the judges to report what's the operating expense, what's the budget here. So it's not as though SCAO is just would be completely guessing as to the amount. They're using the court's actual budget. So I don't know if an individual judge's assessment would be any different. I think that they're both looking at the budget, but that's the problem. We shouldn't be starting from the operational budget as a whole in the first place. If there are no further questions, I'll reserve my time.
Okay, thank you very much, Counsel.
morning. My name is Mark Kneisel. I'm an assistant prosecuting attorney in Washtenaw County. Seated with me at Appellee's table and taking 5 minutes, as Your Honor mentioned, is Aaron Lindstrom. And again, good morning. And Mr. Chief Justice, may it please the court.
Mr. Lindstrom is the solicitor, right?
I beg your pardon. Correct. I beg your pardon.
No. No need for that. I'm just trying to complete the record here.
Thank you. In 2014, the legislature did pretty much what this court intimated or is harmonious with what this court said in Cunningham. And what the legislature is striving to do in both this statute, 769.1K, and any number of other statutes, for example, 769.1F, is codify a system or grapple with a system that is at least dually layered or at least dually variate. And what I mean by that is that the state cannot construct out of whole cloth a criminal justice system each time a new crime is committed, or a civil lawsuit needs to be filed, or can't construct a fire department every time a fire breaks out. We have to have these extant systems, and in general, the state must appropriate some of its generally raised revenue for that necessary infrastructure. At the same time, the vast majority of Michiganders never make particular use of the criminal justice system. That's something that we may all forget because of our day jobs, but the vast majority of Michiganders have nothing to do with this. And contrary to what counsel said, a criminal case starts when a criminal, in this case, kicks a woman in the head, or sells heroin, or uses a gun, or et cetera. So those volitional actions by a very small percentage of Michiganders who pay these costs come from the specific use of the system on their own behalves. And it does behoove them to have a system that's properly funded and robust. So that the second part is occasioned by recoverable, I beg your pardon, that second dynamic, that second layer is occasioned by recoverable administrative costs. There will never be a perfect way, a way to perfectly, precisely balance to the penny those two layers. But what the legislature has done, I think, properly discharged its obligation to try to realize that balance. And when the sun sets on its present attempt, it will continue to do so. I've already managed to mangle my colleague at council table so as to not cheat him out of any of his time. I'd like to consider the yellow light extinguished, and if there's any questions, I can try to assist the court in answering.
No, there appears not to be. Thank you very much.
All right, thank you.
Thank you.
Mr. Chief Justice, may it please the court, I just wanted to echo some answers to the first question, which go to the fact that everything that the state imposes is not a tax. There are lots of categories other than simple user fees that fall outside the area of taxation, such as fines in the criminal justice system, for example. I think no one would argue that a fine is a tax, but it's also not really a user fee. So this is kind of a false dichotomy. It made sense in the context where it was applied, which was in analyzing a Headley Amendment case, which was in the civil context and was looking at whether something really was a local tax or not. But here the question is a broader one, and not everything the government does is a tax. I think another example I'd like to touch on real quickly on the separation of powers point is it's kind of like sentencing, where there may be something where the legislature lays out the parameters, but courts still have wide discretion in exercising judicial power to make specific sentencing determinations, and that's similar here. In fact, this court has even held in the 46th Circuit trial court case that this court has some inherent authority to provide for its own funding. So if that's true, this would seem to be also arguably a part of the judicial power that's exercised in a particular context.
But what are you saying? I mean, let's just assume for the delegation question, let's assume it's a tax, just so we can have the conversation about whether the judiciary can be sort of subcontracted to both set the tax policy and collect the tax. Obviously, the executive is permitted to collect taxes, right? So the legislature can can, ask the executive branch to wear two hats in that way. But I think the judicial branch is a little bit different in terms of delegation, at least according to the U.S. Supreme Court cases, right? In Mistretta, for example, the court says we permit judges in their individual capacities to sit on a sentencing commission, which is not a traditional judicial function. They can wear two hats, they just can't wear them at the same time, right? That's what the U.S. Supreme Court says. So why, in this case, aren't the district court judges being asked to, or the trial judges being asked to wear two hats at the same time?
I don't think so any more than they might be making other determinations. They make attorney fees determinations, for example. They make other ones. I get the point that doesn't go directly to their funding, so it's a little bit different, but they're deciding a bunch of things that are a part of the case that's still a part of the judicial function. Court costs seems to me, pretty directly related to what the courts are doing, and they're not exercising some unintelligible principle. They have to be tied, reasonably related to the actual costs incurred. And so if you can tell from some of the materials in the appendix, for example, that this range is actually fairly small, and exercising a bit of discretion within that range is not exercising the legislative power. This court, I think, has taken a slightly more flexible view of the separation of powers as the federal courts has, and it's recognized that it's only when one court is whole and when one branch is exercising something that's wholly the power of another branch. And so there's a little bit more crossover that's allowed under the Michigan Constitution, according to a number of your cases. If there are no further questions.
There's not to be. Thank you very much.
Thank you.
As the amicus, you now have five minutes.
Thank you, Your Honor. Lisa Speaker for the Amicus Curiae Michigan District Judges Association. May it please the court. I assume there's not a fire-free zone for me. 769.1K is a corrupting influence on our justice system, and it's particularly so for the district court judges in this state who are made to be responsible for the funding of their own court system. The Michigan District Judges Association asks that this court strike down the provision at issue here as unconstitutional under the 14th Amendment of the United States Constitution.
Counsel, the affidavits from the judges are striking and concerning, and I think lay a really good foundation for a lawsuit that might get filed tomorrow based on due process, and that lawsuit might be won. But how do those claims are not present in this particular case, or are they?
Your Honor, those claims were not raised in this case, you are correct, either in the trial court or the Court of Appeals. But our involvement is because we wanted to make sure this court was aware of the even bigger problem that is created by the statute. It's not just about violating statutory authority or violating the Michigan Constitution. What this statute does goes to the core of our judicial system and what our judicial officers are responsible for, which is meting out justice, protecting public safety, punishing people who have done wrong. And when they are being made to fund their own courts with the operational cost imposed through this statute, there is an inherent conflict of interest that has been loathed by the United States Supreme Court authority for many years, since 1927 when we talked about the Toomey case, and then the Ward case in 1972, and most recently in Caperton versus Massey. So this is an insidious problem that it exists, and I think it's important for this court to know about whether or not it was properly raised below. And I don't believe I cited the case in my amicus brief, but I know that there are cases that talk about constitutional issues being raised in this court for the first time, and I have cited those before, and unfortunately I didn't think to cite it this time around.
I struggled with this a little bit. The one way in which I think the concerns that your clients, are they your clients when you write? I don't know how you were.
Yes, Your Honor.
Raised, it is potentially relevant to the delegation question, to the separation of powers question in the sense. Mistretta says that in every case, the ultimate inquiry is, quote, whether a particular extrajudicial assignment, if we think that the judges are being asked to collect taxes, whether that assignment undermines the integrity of the judicial branch. So I read Mistretta to say it's one thing to outsource tax collection to the executive branch and a different thing to outsource it to the judicial branch because of the different role that this branch plays in our constitutional democracy. What are your thoughts on that?
I agree, Your Honor, and part of the reason it's a problem here is because the courts are being required to fund their own system, and the statute allows just the general expenses of the court to be imposed upon the defendants. There are many, many statutory provisions that allow certain types of costs and fines and fees and assessments to be made against a defendant. And none of those are at issue here. But all those other costs and fines really relate, as they appear in 769.1F and 1K, really relate to the specific case at issue. It's the attorney's fees in that case. It's the prosecution costs that are arising from that criminal incident. It's the emergency responders fees that are caused by the incident at issue. Whereas this particular statute allows the general imposition of cost for just the operation of the courts in and of themselves.
I don't completely follow that argument. If you raised 0 cents from the process that's at issue here, your branch, your judges, the district courts would still have a constitutional entitlement under our 46th Circuit decision to being reasonably financed by your funding authorities.
So
if you raise 0 cents, you would still have that entitlement. You'd have a greater entitlement, presumably, the less that you raised by a court cost.
Well, unfortunately, Your Honor, that's not how it has worked. And if you see from the SCAO data that has been supplied to this court, there's a lot of money being raised through the imposition of these general operational costs of the court. I believe it was $80 million in 2017 and 2016. And a lot of that is coming from, I think 80% of that is coming from the district courts' imposition of cost. And so if you say, well, the district courts have an entitlement to operate regardless of whether they bring in a dime of money from the imposition of cost, it doesn't alter the fact that on the ground that the chief judges are responsible to make sure that they have a budget for their court and that they can get funding from their court to make sure their court's operating. Because even though that their jobs are secured through state funding of their salaries, everything else around them comes from their local funding unit, whether it be a city or county. Their staff, their probation officers, the building that they're in, the health insurance that the judges have. And it's very clear from the letters that we've seen from the various judges, which is just a small handful. We did not poll all the judges in our organization, but only asked the board members, the executive board members, to supply some feedback of what they've dealt with. It is an insidious problem of requiring the judges to either cut their expenses if they can't raise enough revenue, or make an agreement, as Judge Appel said in her letter, that they will increase their revenues in order to meet the budgetary requirements that they've been provided.
Okay, thank you very much, Ms. Speaker. Your time is up, and we appreciate you taking the time to represent the district judges. The case will be submitted, and the court will stand adjourned. Thank you very much.